Number 42, People versus Hanza Mohammed.
Before I forget, I'd like to reserve 2 minutes for rebuttal, please.
Certainly.
Good afternoon, Your Honors. Paul Connolly, representing appellant Hanza Mohammed. Your Honors, in this case, the defendant's fundamental right to a public trial was violated when court staff, attempting to implement the court's order forbidding spectator traffic during witness testimony, excluded spectators.
Was there a closing of the courtroom here?
Yes, I submit there was a closing of the courtroom. If we refer just to those, I count at least 6 spectators who were excluded from the courtroom who timely arrived.
And we're told you can't go in because this courtroom is closed?
Well, whether they were told that or not, there's a conflict in the record about that. There are 2 of the spectators who wished to get in testified that they were told that they couldn't go in, even though they were there timely.
So can you clarify, I couldn't understand whether your objection was to the inability or perceived inability of the spectators who wanted to enter before the witness took the stand, or their inability to enter pursuant to the rule, the standing order, had it been properly applied. Is it both, or is it simply the first?
Well, it's both. And the first point we make is that those spectators who timely arrived and should have been admitted into the courtroom pursuant to the court's rule were actually excluded from the courtroom.
So a misapplication of the rule first
That's the first point.
is your argument.
Second point is an ineffective assistance of counsel argument premised on the argument that the court's underlying rule forbidding all spectator traffic during witness testimony is unconstitutional.
So that rule would be unconstitutional under all circumstances? Because my issue is, I imagine that there are a number of judges who have a rule like that. They don't like distractions during witness testimony, but the argument here is that that won't survive constitutional scrutiny.
Yes, yeah, first, I'm not aware of any court that does have that rule. Not aware that any court, other than this one, has the rule forbidding any spectator traffic during the testimony of every witness.
But are you directly challenging that, or just as a predicate to the ineffective assistance
It's
claim?
both. But if point 2 of the brief deals with the constitutionality of the underlying rule in the context of ineffective assistance of counsel. Point 1 deals with the preserved issue. The issue that counsel did preserve is that spectators who ought to have been admitted pursuant to the court's rule.
Counsel, we have a very different record here than we had in the last case you just heard. The judge actually had a hearing here, right? And what were the findings the judge made with respect to those 6, I guess, the 6 you're saying, were not let in, even though, even under the policy, the argument is they should have been?
Well, the court seemed to find that the reason they weren't let in was just a misunderstanding on their part.
Right.
In fact, that the courtroom was open, and they all misunderstood. Everybody,
Apparently did not realize they could go in, I think.
everybody misunderstood, the court
So
felt.
what do we do with that finding? I mean, there's a hearing, there's a judge, there's a finding. What do we do with that?
Well, I have two responses to that, respectfully. First, the appellate division apparently didn't accept that finding, because the appellate division found that part of the cause of the exclusion of these witnesses was the way, or the language the appellate division used was the manner in which court staff attempted to implement the court's order led to the exclusion of spectators who timely arrived. So the appellate division made, in effect, a different finding than the trial court did. The and second response to that is that the trial court's finding is not supported by the record, in that even if the court officer Cummings was accurate when she said she didn't tell anybody they couldn't enter the courtroom, she admitted that she understood that those spectators who timely arrived and gave her their cell phones did so because they wished to enter the courtroom.
And she took those cell phones in anticipation of those spectators being admitted into the courtroom, right? She wouldn't have taken the phones if she thought that they were going to be excluded.
No, that's correct, right. She did not think they were going to be excluded.
And when the court determined that something was amiss outside, suddenly, there's a video that shows people suddenly getting up and going over to enter the courtroom. They're searched and wanted. So is that record consistent with the courtroom wasn't closed as to them? That they could freely just go in at any moment?
No, that's not consistent with any finding that the court was open to them. Now, to be fair, by the time the people got up, the courtroom, everybody would agree that the courtroom had been closed for, I think it's 44 minutes. The courtroom, according to the court's rule, would be closed from 9:35, according to the clock on the video.
Who closed it?
It's closed pursuant to the court's order. Court had an order forbidding spectator traffic during witness testimony, so that's on the court. No question about that. What the court said is that, well, those spectators who timely arrived could have gone in at any time. They were just confused, but the court said, that's not my fault. It's not the fault of court staff. They were just confused, so nobody's at fault, and too bad. The spectators missed the testimony of this most critical witness, but there's...
What in the record shows the contrary, that it wasn't confusion, that they could have just gone in?
Okay, yes, I meant to get to that. Court Officer Cummings testified that when she took their phone, she understood that they wanted to go into the courtroom, and she understood that they would not go into the courtroom until they were given permission. That's point one, and then point
But
two...
she didn't externalize that.
Pardon me?
She didn't say she externalized that, right? She didn't tell the spectators that they couldn't go into the courtroom.
She explicitly said that she did not tell the spectators that they could not go into the courtroom. But she also said that, let me make sure I get this, it can be confusing. So she was asked, did you tell anybody, this is what the judge asked, did you tell anybody that they couldn't go into the courtroom? And she said, no, I never said that. But she also testified that though she understood that these people wanted to enter the courtroom, she never told them that they could. And she knew that, so she knew that they were waiting.
So she didn't extend an invitation to them, and by not extending that invitation, the corollary is the courtroom was closed?
The courtroom was closed because the court had the underlying order forbidding spectator traffic during witness testimony. These spectators out there...
Well, when they turned in the phones,
Yeah.
she didn't let them in.
She didn't, no, she testified that I didn't tell them they couldn't come in, but everybody understood that they couldn't come in until they were told they could come in. And nobody told them. It's undisputed. The record is...
Counsel, on the day that this happened, what day of the trial was this?
It was the third day of the trial, the second day of testimony.
And so many of these people I'm not sure the record is clear that they were there earlier, but this was the same process going on day after day?
Yes, several of them were there. Possibly all of those six. There were 6 people who can readily be identified on the video who arrived timely and were not permitted to go into the courtroom. At least some of them, at least I would say 3 or 4, were there the day before. For example, there's a black man, they're all black, by the way, and everybody else going into the courtroom is white. For some reason, it's an odd fact, but it's the only black person who went into the courtroom during the time in question was the witness, Merritt. And he went in under an escort of DA investigators. Everybody else, the black people were excluded from the courtroom. The people going in and out are white. But I lost my train of thought. Your question was?
With respect to them being out there, they'd been following the court's directives for a number of days.
Yes, they, at least, well, one day. This was the second day of testimony, and there was testimony from these witnesses at the hearing that they understood, and they were all very respectful. They understood they couldn't just barge into the courtroom.
And in fact, they orderly stepped to the side, stayed out of the way, didn't block traffic, waiting.
Yes, they were extremely respectful, and if you look at the video, I mean, it's very, I think, impactful to look at the video. We have 5 people sitting directly across from the courtroom on a rectangular bench, hard bench, respectful, quiet. They're obviously waiting to get into the courtroom, and nobody bothered to tell them they can come in with a
I have one more
consequence.
question.
Of course.
Yes. Should we consider the fact that the judge offered to restart the testimony, and that was rejected?
I've never seen that as a remedy, and it doesn't make sense as a remedy.
Well, why not?
Well, for one thing, then the prosecution would get a chance to do over its testimony. And that is, maybe the prosecution didn't like the way the direct went in the first time, well, now they get a chance to do it over. Moreover, this was, from Mr. Muhammad's perspective, damaging testimony, frankly. I mean, this is a critical witness who identified him as the shooter. The jury would then have an opportunity to hear that critical testimony twice. It's the same jury and the same witness, and now they're going to hear that twice. That would be prejudicial. I mean, I wouldn't want that as a remedy. I mean, so.
Yeah, but
and
you
even
weren't
if did-
there, right?
Well, even if you did, I mean, still, you could tell the jury, like, to disregard all the testimony you heard yesterday during this period. That's very hard to do. I mean, to unring that bell, that critical testimony, that dramatic testimony, identifying Mr. Muhammad as
If
the
it was an
shooter.
appropriate cure, it would eviscerate the right, because you do that in every case. Or you just do a do-over in every case.
Yeah, you could just start, whatever part that people were excluded from, you could just redo. And
Why
then,
isn't it the fault of the spectators that they simply didn't ask to come in, as it's suggested?
well, I point out again that a couple of spectators, more than 2 really, who testified said they were told they couldn't enter. But regardless, the record is undisputed that the Officer Cummings understood that those spectators understood that they couldn't enter. And when they give their phone to Officer Cummings and they don't go in the courtroom, the officer could not help but understand that they thought they couldn't go in the courtroom.
I mean, your point
Nobody-
essentially is that the act of handing in the phone is like the act of taking the number at the deli counter, saying that you want, your number 3 for service now. You're waiting.
Yes, except that if the courtroom is really open, they should be just told immediately to go in. And they weren't, even though the officer herself conceded that she understood their wish in giving her the phone was to enter the courtroom. I see my time is up, though. Thank you.
Good afternoon, Your Honors. Brad Osler for the people. Our position is simply that this was not a courtroom closure, and that short-circuits some of the analysis that would otherwise
Why?
undertaken. Because there was no affirmative act by the court that specifically excluded any individual or group of people.
Well, how is that? The court has a standing policy. The court has officers who are implementing that policy. They're obviously doing it wrong. How is it not a courtroom closure?
Because
Even the AD says the manner was inappropriate and incorrect pursuant to that policy.
I think the affirmative act that would actually be required to effectuate a courtroom closure would be some act, be it by the judge directly or by a court officer, that actually removed or excluded somebody.
Who
affirmatively.
controls the courtroom?
The judge is in control.
The officers that are stationed outside of her door.
So I don't think I could argue that the court officers are not an arm of the court, the judge in
And do you
particular.
disagree they were out there taking phones and giving permission or not? Let's say for the sake of argument, they didn't say anything, but they took phones, they searched people. When the judge said, come in, all of a sudden, they let the people in. So isn't the judge controlling egress and ingress of that courtroom?
I think I would agree that it has to somewhat at least be imputed to the judge, because the court officers are the arm of the court controlling ingress and egress.
Can you explain how it worked when everything was working correctly? How would the officer outside the room know that it's time to let people in?
Our record here does not reflect that. I don't think that was really a topic that was covered in the day-long hearing on this.
So the appellate division says that the people were excluded by a confluence of factors outside the court's knowledge and control. So what specific factors were there that were outside the court's knowledge and control?
I think the number of people gathering and the length of time at which it was happening, and then...
Well, the number of people I don't think would effectuate the exclusion.
No, but I think the second half of that is that the court may not, and I should distinguish, I suppose, the judge may not have been specifically aware of how the court officers were implementing the rule. Again, I don't think the record bears that out one way or the other.
But again, it is the judge who is in charge of that courtroom, correct?
Yes, yes.
I have presided over murder trials and people coming and going inside and outside of the courtroom, where the officers are. The court is intimately involved. Are you saying that in this particular instance, the court simply gave over her duties to the court officers to decide who could come in or out?
Again, I'm not sure I could affirmatively
his.
answer that, but to the extent that we could read into this a little bit, I
But
think
isn't that the problem?
it is true that the record could speak to that question
Well,
specifically.
there's no great leap. The judge is on the bench. The officers are outside the door. The officers are the ones letting people in and out. Maybe it's Cummings who has a full control, maybe not. The judge cannot be aware. But maybe not seeing anyone come in and out gives you a hint, but the judge cannot be aware whether or not the policy is properly being implemented, if any mistake is being made. Which I see as different from what you suggested before, which is you need that affirmative act, which I think you agree that means either the judge themselves or the person they have given responsibility to, right? So why is that not the act, that they are at best, innocently misapplying the rule?
If that's the case, I think we are then moving away from the territory of a strict courtroom closure and into your Peterson example,
Okay.
where you have a brief inadvertent closure. And I suppose we could all debate on what brief means and whether 40 minutes versus 20 or an hour or whatever is considered brief. But there'd be no question, I don't think anybody here could disagree that this was an inadvertent, if we want to call it a closure or an exclusion, an inadvertent one. Nobody, neither the court, the judge himself, or any court officer.
Inadvertent why?
There's nothing on the record, and when I say on the record, I would, I suppose, point specifically to the video, since that's perhaps the strongest evidence of what occurred. There's nothing on that video that actually shows somebody tried to enter and was denied entry. And I say that with the understanding that several of the witnesses who testified during the hearing the next day said that they were told they could not enter, but the video belies that.
Yeah, but there is a way to have avoided, let's put aside for the moment whether or not the standing policy is constitutional. There is a way to avoid this, which is every time the courtroom is closed, the judge can announce that, and when it's open, the judge can announce that from the bench and make sure that the officers are aware. But to simply be on the bench and assume that the officers are figuring out when it's open, when it's not, strikes me as that is the judge making a choice to let the officers decide on their own, exercise their own discretion. I don't see how that's constitutional.
Well, I would suggest, Your Honor, that the problem that would be created by holding that this type of rule or restriction is unconstitutional is that we're now, in some respects, placing a burden on the court or the court officers or a combination to a large degree, usher people into the courtroom.
Isn't there presumption that the courtroom is supposed to be open?
Yes,
And that is the responsibility of the court.
it would certainly be charged.
In this particular instance, the court says it believes that it is distracting to have people getting up. And doing what they did here, do you think that this broad statement, nobody in, nobody out, during witnesses, that is okay? That is not overly broad?
I don't believe it is overly broad, and I would say that because of the case law from this court that would suggest that controls on ingress and egress like this are permissible.
Specifically, these kinds of orders, I don't think it's in the record, but you'll correct me if I missed it. Are there other examples of this type of order specifically that you can point to?
I think Cologne or Colon might be the closest case, and granted, that was specifically, I believe, with respect to voir dire and not the rest of the trial.
Right.
But I don't know that it would be particularly wise to really differentiate voir dire from the
But you're not
rest.
aware of any widespread or common practice of implementing a standing order of this nature, I take it?
Can't profess to be, no. And there doesn't appear to be case law where this is quite as broad a rule was put into place.
And the appellate division said it did not, it specifically said it did not approve, right?
I think that, I don't
this
think
rule.
that the appellate division would be alone in casting some question onto whether a rule of this is the most wise decision or most wise rule to put in place, but I think it's a permissible one.
But that
Because-
also
but it-
suggests that the burden you were complaining about on the court is really a function of this odd rule that the court has. So maybe it is constitutional for the court to say, I'm not having anybody come in while a witness is on the stand, but perhaps then the court is not really in a position to complain about the burden of having a court officer every time a witness goes off the stand to go out to the hallway and say, the court is now open for anybody who'd like to come in, and in 5 minutes when the next witness comes on, the court is going to be closed, you're not going to be able to enter. If you
And that-
want to have a rule like that, then that's your burden.
And that would make sense, I understand that, except I think that is then inviting problems that are going to be legitimately outside of the court's control, even with the exercise of some
But
due
isn't the
diligence.
problem of the standard policy, you can have a trial going on, and the court certainly has the right to control. It is one thing if a record establishes there's a person in the audience, they keep coming, they keep popping up and down and going in and out. That person can be told, either you're in or you're out. That is reasonable. But to broadly state that nobody can come in, you're saying that's okay?
I do think it is, and I think part of my reasoning for that, Your Honor, is that if the alternative is to essentially wait for interruptions to occur, perhaps repeatedly, it's somewhat defeating the point
It's a
of,
public trial. Interruptions happen.
I understand that interruptions can happen, but I
They
don't.
do.
but-
They do.
They do happen, certainly, but I don't think it's improper for the court to try to regulate or head that off as much as it can. And given that this rule neither closes the courtroom nor actually excludes anyone, I don't see how the rule is actually itself improper. It appears, watching the video from the hallway, it certainly is an odd sight to see a relatively large gathering of people arrive. But I think everybody's been in the position where you don't want to be that one to try the locked door, and that's legitimately what appears to be the case. by virtue
It
of
wasn't
the video.
simply a locked door. They gave their phone, and then when they were ushered in, saying, "You can't come in now," there was an additional. They're searched outside, and I know that's outside the record. In order to come into the courthouse, you are searched. You walk through magnetometers. They're searched. That video shows them. They've already surrendered their phones, but they cannot simply walk into that courtroom until after the officers search and wand them. Is that not true?
That is what the video depicts, but that same action, the wanding or further search, could have also occurred just inside what were the outer doors of the courtroom as well. It didn't have to necessarily occur there, by which I mean someone could have tried to enter the courtroom, actually gone up to physically open the door.
Did you say that the door was locked?
It was not locked. Well, I mean, prior to 9 a.m., before any activity was going on, it was unlocked, I think, at about 5 of, something along those lines, based on the testimony of one of the officers. But throughout the rest of the time, it was certainly unlocked.
But there are times when the door is unlocked, but the judge has the public out. The times when the judge is conducting business with counsel and the accused, correct?
Sure.
So it doesn't have to be locked, but they're not allowed in at a particular time. There are a number of reasons why the spectators can be kept out, even with the door unlocked.
Yes, but, and again, I think that speaks more to whether or not an actual closure occurred by an affirmative act of the court. And it's not borne out, I don't think, by the fact that the door was unlocked and no one actually...
What's the spectator's fault here?
I mean, I think so, based on the fact that no one made an effort to try to enter.
Thank you.
Thank you.
Just a few items. The Colon case that counsel referred to involved forbidding spectator traffic during the jury charge. And this court, in that case back in 1988, said that the reason why we're approving of that restriction for the jury charge is that it's unique in that the court itself is completely invested in charging the jury and may not be able to adequately police the courtroom. And the jurors have to pay especially close attention because the law can be hard for them and for attorneys to understand. So that ruling in Colon was specific to the jury charge. And this court in Colon explicitly said that it was not deciding whether the same rule, an exclusion of all spectator traffic, would be appropriate in any other part of the trial. Given that that was the state of the law, there was absolutely no reason for counsel, defense counsel in this case, when this issue arose, to volunteer to the court incorrectly, as a matter of law, that the court had the power, is the word that he used, to forbid spectator traffic during witness testimony. So that was a grave error by defense counsel, failing to preserve, as a matter of law, the issue of the constitutionality of the underlying order. But as to the issue raised in point 1 of the brief, our position is that the exclusion of the spectators from the courtroom in this situation was not inadvertent, as this court found in Peterson, where the problem was forgetting to open a courtroom door that had been physically locked. Rather, here we had an involved court officer who was taking the phones from these spectators and understanding when she did so that these spectators wished to enter the courtroom. And that court officer, as part of her actions, did not, for no reason that appears on the record, did not tell them, hey, courtroom's open, go on inside. And this brings up the
Yes,
point
he
that...
did. Okay, there's a back and forth about whether or not she had to do that, but let's say she takes the phones, they turn around, they go sit on a bench, right? But they can see the door, they can see the officer. And then 5 minutes later, the officer gets up and opens up the outside door, not where you have the alcove going in, just that outside, just opens it, doesn't do anything else, and they still stay on the bench. Does that not signal it's open?
No, because
I'm not saying that happened here, I'm just giving you a hypothetical.
No.
I know it didn't happen here.
Well, what I do know, the record does show that people went in and out of the courtroom during this period. 8:57 when the first spectator arrived, to 9:35 when the witness took the stand. People did go in and out of the courtroom, that's true, the record does show that the door was opening. But to these spectators, that door was figuratively, but really closed. So an open
But
courtroom
I
is-
get your point, but I'm not asking that. My hypothetical is that the officer keeps the door open as opposed to people walking in and out and the door is opening and closing, and those people may appear to be the uniformed or other people who would be allowed to move in and out at that time. Could the officer have done that to communicate courtroom's open? Does the officer have to speak to them, have to announce the courtroom is now open?
No, he doesn't have to, it doesn't necessarily, he has to communicate. There has to be communication between the officer and the spectators. And here, the only communication really was implicitly that you can't go in.
During
Because,
this time, counsel, during this time that it should have been open, but it appears to be closed, did anyone come out of the courtroom?
yes,
Doesn't that signal to them that it's open? Because you can't leave either, right?
you can't leave, yes, that's true, but these spectators seem to understand, they seem to think that certain people associated with the trial could go in and out, so
But
they
were
would-
they court officers who were coming in and out, or were they spectators who were coming?
They were well, the only spectators who came out were affiliated with the district attorney's office. They were interns, as
Because we've been hearing this is the second day of this process,
Yes.
and they knew the process, so they knew they couldn't go in during witness testimony, and they couldn't leave. So if they see people coming out,
yes, they seem to think, though, that these and you have to read the testimony of these witnesses, I'm sure you have, but they seem to think that everybody who was going in and out, they had noticed that they were all white and they were nicely dressed. And the implication was, I think, that they thought that these were people who were associated with the trial, which, in fact, they were. They weren't spectators. They didn't see any spectator going in and out.
Well,
They
but
s-
they don't know that emphatically. I mean, they were surmising.
Yes, they
It's
were
to
surmising.
To borrow another word, it was the atmospherics that aren't on the record, that people are making assumptions, but the record doesn't say that, right? I mean, the record indicates that people were coming in and out of the courtroom.
Yes, but the record also does make clear that this court officer, Cummings, understood that these people who were waiting, she knew they were spectators, they'd given her their phone, she understood that they were waiting for permission to enter. So regardless of whether people were coming in and out, she understood that they needed permission to enter.
You want to take
So-
30 seconds on the ineffective assistance of counsel since your red light is on?
Yeah, I would just say that this court has never held that a rule barring spectator traffic during witness testimony passes constitutional muster. And I would refer to the Turner case, and I think it's 5 New York 3rd something, where defense counsel raised one issue in support of a result, one argument in support of a result he wanted. In that case, it involved a lesser included offense. Defense counsel in that case argued that the lesser included offense shouldn't be charged because it wasn't really a lesser included offense, but failed to argue statute of limitations. In this case, counsel raised one reason why this exclusion of spectators was a problem, but failed to raise another issue. And specifically, defense counsel in this case failed to raise the constitutional issue of whether the underlying order was unconstitutional. And I submit, had the counsel raised that, this would be preserved as a matter of law. This constitutionality aspect of the case would be preserved. Regardless, however, I submit that this court can and should reverse the conviction on the basis of the way this order of the court was implemented, leading to the exclusion of multiple spectators eager to enter the courtroom from a material part of the trial.
Thank you.
Thank you.
Counsel.